Great. Welcome back to House Education, January 18th, 2023, afternoon session. We're going to be discussing some work that the State Board of Education has done. Then we're going to transition to a little bit about homeschooling and some of the proposal or a proposal from the administration. Before we dive in, however, a couple of our members have requested a moment to just talk about a resolution that they're sponsoring in place of the previous chair, the member from Shelburne.
Oh, great. Thank you. So those of you who were on the committee last year will remember that Kate Webb, Chair Kate Webb, led the charge on a resolution for Mentor Vermont, which is a statewide mentorship program that does a gathering here in Montpelier on February 1st, where they come to the State House with their mentors and their mentees, and there's sort of a recognition, and I believe there's a lunch that the governor will be attending over at Capitol Plaza. So Representative Brady and I have co-sponsored the resolution this year, and I realized yesterday that actually last year it was just a resolution that was sponsored by the entire Education Committee. So if folks are interested, I can circulate the text of it, but I think it would be really lovely if folks would consider signing on, since mentoring relationships are so fundamental to the work that we do in education. So, and I will have a sign-up sheet tomorrow.
Thank you. All right, we're going to welcome back Jennifer Samuelson, Chair of the State Board of Education. I'll let you repeat that. And so just to put it in context, since we keep jumping around, we're going to talk about the work that the State Board has done with rulemaking. Remember, they sort of take the law and turn it into rules. And in some cases, you sort of, quote, open up the rules, and you can actually go in a lot of different directions that may be outside of the specific legislation that prompted the opening of those rules. The, quote, Rule 2200 series touches on a lot of areas. Today, we're really going to talk about sort of the decisions that the State Board has made within that concerning, once again, approved independent schools that receive public dollars. So again, this is sort of to let everybody know kind of what's happened, what's going to be taking effect this year, next year. As we think about certain things that we want to do. I don't think I have anything else to say. So Jennifer, if you'll take over, that'd be great.
Sure. Can you all hear me? Okay.
Yes.
Perfect. So again, I'm Jennifer Samuelson. I'm the chair of the Vermont State Board of Education, and really appreciate being invited back to talk with you this afternoon. So thank you for that. I'm also going to be joined at some point by Emily Simmons. My understanding is that she is currently finishing up a different meeting and will be joining us to really speak about the special ed aspect of Act 173, because that is something that is really less within the purview of the State Board of Ed, and I thought it would be helpful to have her come and answer any questions that you might have specific to that. So I thought what I would do is sort of share my slideshow presentation, and I'm happy to share my screen with you, or if you all have it on your screens, I can just go through it kind of like we did last week.
Great. Does everybody have it up? It's on our website. Yeah, we won't need to share screen. Just sort of tell us when you want us to switch slides.
Perfect. All right. So just starting at the beginning, I thought it'd be helpful to just reiterate and sort of ground us with what Act 173 of 2018 charged with, and it was an act relating to enhancing the effectiveness, availability, and equity of services provided to students who require additional support. Next screen, I also pulled out, and this is in the language of our Rule Series 2200, so beginning with Rule 2200 itself, the rule states that the purpose of independent school approval rules is to assure the effective, available, and equitable educational opportunities for students enrolled in Vermont's independent schools in accordance with state and federal law and aligned with the purposes set forth in Act 173 of 2018. So this was, the state board kind of lifting that charge from the act itself and, starting that transition into the substance of the rules themselves. The next screen, I thought it would be helpful to just review. There were really two categories of changes that were required by the language of Act 173. The first category were changes to rules governing special education services. And those changes sort of flowed into updates to Rule Series 1300, which is special education finance and census-based funding, and Rule Series 2360, which are the special education rules. Those changes became effective on July 1st, 2022. The second category of changes required by Act 173 were changes to the rules governing access to special education services for publicly funded students attending approved independent schools in Vermont. And so that aspect of the Act flowed into Rule Series 2200, which again, I think I said this last week when I met with you. I ended up being the chair of the 2200 subcommittee for the State Board of Ed and really oversaw the changes that were made and took us through the APA rulemaking process. So it is in that capacity, that I'm here today, as well as my current position as the chair of the State Board of Ed. The next slide is further breaking down that within the Rule 2200 series, there were two subcategories of change that the State Board oversaw. Again, the first were changes that were required by the Act. So this would be acceptance of students with special education needs at approved independent schools that are eligible to receive public tuition funds. It also pertains to the provision of special education services to students attending approved independent schools that are eligible to receive public tuition funds. And these rules will go into effect on July 1st of this year. So the rules are on the books. People are aware of them. Presumably schools that are interested in continuing to be eligible to receive public tuition funds are working now to become in compliance when the rules go into effect on July 1st. The other changes that we made within the 2200 rule series were changes that were within the scope of the board's authority. And so under 16 VSA section 164.7, the board has the authority to make legally binding rules that are within the scope of its authority in order to assist with the interpretation, implementation, and enforcement of education statutes within the limitations of legislative intent. So, Act 173 was a directive from the General Assembly, but once the rule series is open, we have the authority and the ability to, go in and tinker with other rules that are still constrained by legislative intent. So we kind of took the opportunity with the rule series being open to update other rules without derailing that Act 173 rulemaking process. And those changes that were not related to Act 173 became effective on May 10th, 2022. So the next slide just briefly overviews the changes that were made that are not related to Act 173. So these are changes that are already in effect. So the first is Rule 2223.9, which establishes a more rigorous, comprehensive, and transparent process to govern the investigation, adjudication, and disposition of complaints. So we really pulled that process out. And the one thing too that we did, and I'm happy to speak more about this or have Emily speak as well, is we created sort of a middle ground. So I think before it was either a school was fine or a school was not fine. And we've created a middle ground where in the first instance, the agency can provide technical assistance. If it finds that a school is not in compliance with something, it has the opportunity to provide technical assistance. And then the other thing that we also created in this change to the rule is that we have the ability now to put a school on probation. And again, this is, the state board is kind of the final arbiter of a process. But that would culminate with the school being on probation if, the agency felt it was appropriate, and then there was a hearing before the State Board of Ed, and the state board also determined that probation would be appropriate. The next change that we made that is effective as of May 10th is that Rule 2224 now explicitly recognizes the New England Association of Schools and Colleges and the Association of Independent Schools in New England as accrediting agencies. So we just pulled that straight into the language of the 2200 rule series. It had been that the accrediting agencies were listed in the Rule 7000 series, but we took a look at that and realized that most of the 7000 series really cross-referenced or cited other rules or statutes. And so the plan is that rule series will sunset. The next changes that we made were in Rules 2226 and 2227, which specifically requires compliance with two key anti-discrimination statutes, the Vermont Public Accommodations Act and the Vermont Fair Employment Practices Act, as conditions of the application and the approval processes. And again, when we were making these changes, we cited the statute. We cited the acts themselves. We didn't cite the language because we felt like it would give the rules more room to breathe. And if the legislature changed the language of those rules, or I'm sorry, if the legislature changed the language of those statutes, our rules will immediately be in compliance with whatever that changed language is. So we thought that, that strategically made sense to craft the rules that way. Also in Rule 2227, we now require that any schools that are operating a boarding program must be accredited by an approved external accreditor unless they are licensed by DCF. And then the final sort of large category of changes that we made are in Rule 2229.1A, and this sets forth specific rules that require anti-discrimination in enrollment and admission policies at independent schools. And Rule 2229 in general was a complete rewrite from the version that we submitted to ICAR to the version that was ultimately approved by LCAR. And I'll just keep going unless there are questions.
Actually, let me hold you there to see if there are already questions before we lose this thread. I'll just ask under 2229.1, does it say what those policies must say? In other words, to me, you're requiring that they adopt policies. Does it list the language for those policies?
So, and I do have a slide, it's the final slide in the presentation, but basically this was something that the subcommittee and frankly, the Act 173 advisory group really worked hard and deliberately to craft language that on the one hand recognized the independence of independent schools because, I think the blessing and the curse of independent schools is that really no two are exactly the same, right? So we wanted to craft language that was really more of an open framework so that everyone knew what framework they were living under, but we still created room to breathe. So what we did was required, that first of all, we clarified that the beginning part of the admissions process is that a parent or a student must voluntarily submit the application. So it's coming from the family. The second is, and I should back up. This is what has to be posted on a independent school's website. So there's a written enrollment policy that states that first of all, the family must initiate the application. Second of all, keeping in mind that there are, for instance, ski academies that might require a certain level of skiing or snowboarding. There might be particular requirements for an independent school. So we wanted those to be included in the written enrollment policy, but at the same time, any condition could not disadvantage a student based on a protected class. Or a student's actual or suspected disability or the student's socioeconomic status. So we thought it was important to say, you can have an enrollment policy, but we want to know what that enrollment policy is, and that enrollment policy cannot be discriminatory. And then the third thing in 2229.1A is what is the school's process for making enrollment decisions when the number of applicants exceeds capacity? Because there might be times that maybe there are 5 applicants and there are only 3 remaining slots. How does the school make that decision? Again, recognizing that independent schools have, a mission that they must follow, we thought it was important to say, okay, you're going to have a plan for how you're going to pick which 3 of the 5 students you choose, but it's important for the public to know what that process is. So that was the balance that we struck there. And then the final step in that process is that the student shall be accepted for enrollment in a non-discriminatory manner and consistent with the school's written enrollment policy. We called out in the language of the rule that no student shall be denied acceptance for enrollment if the reason for denial is that the student is disabled, as defined in Section 504 of the Rehab Act, as amended, or that the student is eligible for special education or undergoing a comprehensive evaluation process for special education. And then we reiterated again that no student shall be denied acceptance for enrollment on the basis of race, creed, color, national origin, marital status, sex, sexual orientation, or gender identity, or any other classification protected by federal or state law. And I want to point out too that one of the big changes in this rule as it now sits before you is, and Emily again can speak more to this, but the first step in the enrollment process is that the student is accepted. It is at that point that any special needs come into play, and then there are requirements that the school work with the LEA and members of an IEP team to ensure that the student receives the special education services that it needs. But at the point that the student or the family is requesting to be accepted, that information is not known to the school and it's not part of the school's decision-making process.
All right, I think that sort of bears summarizing and repeating. So what you're saying is that for an independent school receiving public dollars, the enrollment process is number 1, the student applies and is accepted before there's any discussion of accommodation for disability, or any basis of not enrolling a student based on those protected classes.
Correct.
Okay. Representative Brady has a question.
Can I to do the same thing,
Please.
clarify?
Yeah, keep on clarifying. It's
And,
great.
and that under this rule now for independent schools, their admission policy has to be public or transparent to a degree that it's, the public could find out how, if they have to choose between students, what criteria and system they're using.
Correct. So they must publish, maintain, and follow a written enrollment policy. So again, as the subcommittee was crafting this language, we thought it would be problematic to say, this is how you need to set your enrollment decisions, because every independent school might be grounded in a different area. And so that's fine. But the mission needs to be published, the enrollment procedures need to be published, and the school needs to follow those written procedures.
All right, so that's there's a distinction there. I think it's not transparent sort of how they make the decisions. Well, there's part of it that's sort of like understandably done behind the scenes and part of it that's public. Is that fair to say? And I also just want to clarify that it's both their enrollment procedure or acceptance policy and how they decide when they got too many students. It's both of those things.
Okay. I'm sorry, can you repeat?
I don't think I can, but that's probably good. All right, is there any part of sort of the enrollment procedure that is not transparent then?
The way we crafted it is the enrollment process is published and it is written. So yes, the way we wrote it, you should be able to go onto an independent school's website and see, what the enrollment process is. we had sort of a seminal meeting in the 2200 subcommittee, I believe it was early February last year, where we were really trying to break down what this enrollment process should look like. And it was something that apparently the Act 173 advisory group had struggled with. It was something that our subcommittee had struggled with. And when we really talked about it, we're like, okay, you know, and again, we were taking directive from the legislature. So when the legislature was discussing this in 2018, would a sibling preference be okay? And everyone in the room said, well, yes, we feel like that would be an acceptable preference, but it would need to be stated on the website.
You said would or would not be stated in their enrollment procedure.
I believe that it would be stated. So again, I mean, if you're going to pick student A over student B because student A is a sibling, now you've created a preference for siblings, and under the rules as they're written, that preference should be stated on the school's website and contained in its written enrollment materials, just so that we all know, what's the field that we're playing on.
Great, thank you. Representative.
My question is, so they get to set that, but then do you do a review of it to make sure that it meets any sort of standard after they write it?
So right now, the state board is, seeing schools that are coming up for approval or reapproval. So if a school is coming up for approval in the first instance, that approval granted by the State Board of Ed, and again, this is we're the last step in a very long process. So the agency goes in and it sees the school and it reviews the materials. The agency creates a report. That report goes to the school for its consideration and comment. It comes back to the agency. The secretary makes a final recommendation that goes before a state board subcommittee that reviews all of the information. And once the subcommittee has reviewed everything, it then comes before the full board for our deliberation. So if it is a school that is being approved in the first instance for the first time, that the approval under our rules is only for a period of 2 years. And then beyond that, approvals and reapprovals would be up to a maximum of 5 years, but the State Board of Ed has the discretion to make it for a less period of time if we choose.
So just following up on that. Yes, it makes sense, but my question is, so if somebody was approved for 5 years last year, do these new conditions that take effect July 1st, 2023, not really affect them until they're up for renewal 4 years from now?
So that is a great question, and something that we had discussed when we were creating the rules. And actually, we had a State Board of Ed, our monthly meeting earlier this morning, and that again was a topic of discussion. And so, the State Board of Ed feels very clearly, I said it earlier, I'll say it again, that if we were approving an independent school now in February or January of 2023, that school, doesn't get a get out of jail free card or get a buy for 4.5 years until they're up for reapproval. The way these rules are written is that they become effective. Certainly the ones that were not related to Act 173 became effective last May. The ones that do pertain to Act 173 become effective this July. And what we've already started doing with regard to the rules that became effective last May, so all of the anti-discrimination language, which by the way was on the books. I mean, we didn't do anything with that other than to really put in clear print that no one should be discriminating, and that we are expecting compliance with the Public Accommodations Act. So we lifted that language and that expectation and, put it down in the middle of the rules. Every school that's up now for approval or reapproval has to sign a certification that they are complying with those rules as they went into effect last May. And then to your question about, well, what about the schools that are already approved that aren't up for reapproval right now? I know personally, the district where I live, our superintendent has sent out a request to all independent schools who educate our resident students, seeking confirmation that they are complying with this language, and then requesting, written certification from the head of school, a link to the school's website that would then, demonstrate compliance. And so I have asked her to come in and speak to the State Board of Ed about, what my district is doing, with the idea that if other districts aren't doing this, that maybe this would be a helpful tool for them to capture schools that, should be complying with the rules that are currently in effect.
Great. Thank you. We may have taken you off course as you're running through
Oh,
things.
that's okay.
And so if you wanted to sort of reset.
all
and go
relevant.
back-
Sure. So, yeah, I mean, it's all relevant and it all kind of fits together. So I think the next line of where we kind of paused is, I'm not going to go over this, but I did want to include for the committee the full language of Rule 2226, which is the application process, and everything that a school is required to include with its application. So that's, slides 7 and 8. And then kind of the corollary, what the state board is looking for when it's considering an approval of an independent school. So the full text of Rule 2227 is located on slides 9 and 10. And then I just pulled out in slide 11 the specifics with 2226.6, which indicates that an application for initial approval or renewal of approval shall contain a demonstration that the school substantially complies with all statutory requirements for approved independent schools, with documentation of the following. 1, a statement of non-discrimination posted on the school's website and included in the school's application materials that is consistent with the Vermont Public Accommodations Act with the site and the Vermont Fair Employment Practices Act with the site. 2, an assurance signed by the head of school that the school complies with the Vermont Public Accommodations Act in all aspects of the school's admissions and operations. And 3, a description of physical facilities, including plant, materials, and equipment, and assurances that the facilities meet all applicable state and federal requirements. And then the next slide shows sort of the parallel, what the state board needs to find to approve a school. So 2227.8, and this of course is just, one of the things that we're finding in our approval process. But 2227.8 is a finding that the school substantially complies with all statutory requirements for approved independent schools and the board's rules for approved independent schools, including non-discrimination in admissions and operations and requirements relative to its facilities, fire drills, and the immunization of students against disease. And then we also added in, thinking that this would become law, and it did become law, 2227.13, that the school complies with legal requirements concerning non-discriminatory school branding. So let me pause there because, again, the final slide is 2229.1a, which, we've just spoken about. And so, at this point, I'm happy to answer any questions that you have. And then, once we get into the realm of special ed, I think I'll probably turn it over to Emily.
Sure. Yep.
My question is.
Representative Stearns' question.
Yes, my question is specific to 2227.5, just getting clarification on that. I don't know if I should hold off to the next presenter because it is a question regarding special education, I believe.
Let's give it a shot.
Okay. So just looking at that, it looks like it's an or statement. So for teachers, a minimum of a bachelor's degree in their field of instruction or substantially equivalent time and training and experience in their field of instruction. Could you just help me understand how that plays out when we're talking about special education? Because I would think a licensure would be needed in that course of study. And I don't know if there's anything, like what would substantially equivalent time and training and experience look like for special education? Does that make sense?
That's great. And I would ask you to expand that into mathematics or, a typical classroom subject.
So Emily, I'll defer to you.
Sure. So it's Emily Simmons, General Counsel for the Agency of Education. I'm so sorry for joining you late. I was double booked for this time, but happy I could be here. The qualifications for staff in independent schools are different than in public schools. So what you're seeing here is the standard to teach in an independent school, which is an or statement, a bachelor's degree in the field of instruction or equivalent time in that same field of instruction. So that would answer the math question, I believe. There's no hard and fast rule for substantially equivalent time when it comes to that option for general curricular areas. This is evaluated by our Agency of Education staff who conduct the site reviews when a school is up for approval or renewal. So they are looking more in the context of the responsibilities of that staff member and their background to determine if they meet this standard. For special education, there are instances where a licensed person is required to deliver a service. Those I would say are tied back to a particular student's particular IEP and whether there is a service indicated on that student's IEP that in order to meet IDEA requirements must be delivered by a licensed professional. That in our independent school framework is actually an obligation of the student's LEA, their supervisory union of residents, to ensure that for all their students, regardless of where they attend school, they maintain their legal obligation to fulfill that service page of the IEP. So there will be a patchwork of different approaches to deliver those services. It might be a licensed person who's on the staff of the independent school. It might be a licensed person who is in the employment of a school district who serves the student in the independent school or in a different setting when they need that service.
Can I ask a clarifying question? So I'm an occupational therapist, and I know firsthand that there's a workforce shortage in the field of occupational therapy. And I also know that occupational therapists often appear on children's IEP plans. So hypothetically, if a child has an IEP plan that requires an occupational therapist and there's not one anywhere in the area, would that be exclusionary criteria for that child to attend that school if that service wasn't available?
I don't know the legal result. Would that be exclusionary? I know how the system is set up to address the need of that child. And it's that the responsibilities on their LEA to procure that service for the student. And the obligation is not under these rules. This is the big improvement that I think the state has made. The obligation is not on the student to find a school to attend that offers that service, right? They should have, as a civil rights matter, they should have the same options as their non-disabled peers in selecting a school to use that tuition at. So it is really difficult. I mean, you have really hit the nail on the head in terms of the staffing and matching available staff to needed services for students who aren't just in their public school with the full staff. But the rules have a sort of graduated dispute resolution process to give the school district personnel with the legal obligation and the independent school personnel who have the student in attendance every day a path to resolve and solve those problems, which can be graduated all the way up to a formal hearing where a hearing officer would say whose job is what and who's fulfilled their responsibilities or not.
And one more follow-up question, I apologize. When you said a site visit would I would want to make sure I'm hearing you correctly. If there are questions about if the services that the parent or child feels like should be provided are being provided, going back to something we learned yesterday, those site visits are complaint driven. Is that correct? No? Okay.
Yeah, good clarification. Site visits come about to verify the application for approval or renewal. So that's a cycle of the 2 to 5 year process that generates an application, a site visit, and then a written report and recommendation to the state board. A complaint could result in an investigation that maybe we determine a site visit is needed to gather facts on the ground. But when we say site visit, we really mean as part of the application and approval process.
So I'm just going to repeat something and correct me if I'm wrong. Going back to the question of somebody who might need occupational therapist or speech language pathologist and they're on an IEP, the ultimate responsibility that child receives services is on the I'm going to use our local term, the supervisory union or supervisory district, even if that means they have to find somebody and place that person in the approved independent school to provide those services.
That's correct. That's a matter of federal law that the state really can't get around. IDEA gives that legal obligation and all the legal mechanisms to enforce that mechanism as between a student and their parent or guardian and their public the supervisory union.
Before we dive any deeper into sort of the special ed relationship, any further questions on general ed and the rules that sort of govern that? I had one, I can't remember what it was. Further, I guess I will ask, what you had said was that really an approved independent school doesn't necessarily have to have teachers that have bachelor's degrees, for example. But that they have to have some undefined substantive or substantial experience. And that's sort of a subjective call. There's no written measurements for that. Would that be correct?
That's evaluated on a case-by-case basis for that particular school. There's no hard and fast number of hours that we've established.
Great. Well then, Emily, why don't you talk a bit, and let's just sort of, use some examples, but the relationship between the non-operating school district, non-operating meaning they don't have a school, but does within their school district have students who are on IEPs that need to be served at an approved independent school. How was that relationship previously, and how has it changed under Act 173?
So I'll speak about the status quo, and because we did not have rules governing the status quo, it's not going to be what happened in every case, right? It's the most typical fact pattern that we would have been aware of, but it was unpredictable out in the field what would happen without this set of rules. So the case study that was most worrying from a civil rights perspective is that you could have a student who got to, say, 7th grade in their school district. They attended 6th grade at their local public school, and then for 7th grade, then had tuition payment rather than that school operated by their district. And they, with their parents over the summer, look at the options, which are any number of public schools that they can get to every day, depending on where their parents go to work or what they need to do during the day, and some approved independent schools that meet the same criteria. You could have a student with an IEP that calls for, what would be a good example? Some speech language pathology services in the student's IEP. And when the student and the family speak with an independent school, they say, great, we'd love to have you. We do not have any approval from the state to offer speech language pathology services. We have several categories of special education approval, but not that one. So you can choose a different school and get those services, or you can sign away your ability to have your speech language pathology services and then attend here. You can sign away your right to FATE with your school district. And in many cases with students that age, that was the more attractive option, just given everything going on in their life, so that we would see students go off of their IEPs in order to attend the independent school where they wanted to go, where most of their friends were going, where their sibling had attended, whatever the case may be. You would have other cases where the student's needs were perhaps more severe, and there was no ability for the student to even benefit from their education without those special education services. And so they would really have no good option at that school and would be looking at a different option for either public school or a different independent school that did have those services. So that is, almost textbook discrimination based on disability that we had in our system. These rules instead do away with the system the state had for categories of special education at independent schools, right? So there's no longer a set of approval where a school has some but not all categories of special education. Every independent school that intends to accept public funds is deemed to also be providing all categories of special education as needed. The second area of improvement is that enrollment process. The process between the school existing and being available to enroll publicly funded students and a student expressing interest in attending and actually making the connection to get enrolled on a non-discriminatory basis. So we were worried about things like a perception of not getting services at the school, or so to speak, coaching out of students with disabilities. And so everything that you see in Rule 2229 is the state board's good work in putting in protections against those outcomes for students with disabilities, to make sure that in every way, a student with a disability and a student without a disability would be on equal footing to go to the approved independent school that they want to attend.
So if we go back to your example of the student who needs speech language pathology so now what they go to the school, or they go through the enrollment process, and in your previous conversation, the school was able to say, we don't have a speech language pathologist on staff, you can sign it away. What's the conversation look like today?
Today, the student attends and submits an application for enrollment without any information going in the first instance about whether or not they have a disability or need special education services. Then after the student has submitted their application, the independent school and the supervisory union will work together as adults, not involving the student and telling them to go a different place, in comparing what the student needs and what the independent school can already provide, and identifying any gaps that the supervisory union would hopefully offer to fill. And if the supervisory union and the independent school cannot agree on how to fill any gaps, to go through a dispute resolution process to get a plan for that student to have services at that school, if at all possible, with the recognition that there will be cases where it might not be possible and a route for the students to receive the services elsewhere.
And would that disqualify that school from being an approved independent school that can receive public funding?
It does not.
Representative Austin has a question.
Would like teleeducation, like could students get those services, like speech and language, for instance, remotely?
Perhaps, depending on the service. There's definitely, the intention is to provide room for creative thinking between the supervisory union and the independent school to come up with any number of solutions and it's very specific to that student and that student's services plan.
And I think, if I might just jump in here, it's important to recognize that the number of students with special needs isn't changing. What's changing is the ability of these students to go to the school that they choose to go to, and the obligation of the school to work with the LEA to ensure that the students are receiving the services to which they're entitled.
I'm going to ask just another scenario before I move to some more questions. So let's take a ski academy and a student with a physical disability. That's not going to be on the application. I mean, I guess this is kind of way out there, but supposing they are accepted, and then the issue of the disability comes to light, and if the sort of programmatic mission of that school includes ski racing, how does something like that get resolved?
I'll take that one. It will be really It really would be fact dependent. I know that's the kind of thing you expect to hear from a lawyer, but it would really depend on the school's non-discriminatory enrollment or admissions policy, right? Are admissions competitive on the basis of skiing ability, or is there a minimum standard of skiing proficiency that's good enough to get any student in? That would be factors like that would be really, they would determine the outcome. Also, the students' particular adaptations to be able to ski would make a huge difference. Has the student been skiing for many years with adaptations? Does the student's disability actually impact their ability to ski? Different facts would get you a different outcome every time. But what would be the same is the admissions policy of the school could not be discriminatory.
All right, I'm going to sneak in and ask one more before I go to Representative Brown and Representative Stone. These rules only apply to schools, or these rules only apply to schools within Vermont?
Correct.
Okay. All right, thank you. Representative Brown.
Okay, thank you. I'm going to see if I can remember my question. So if the goal of what we're trying to do with this new rule series is to make sure that schools receiving public tuition aren't discriminating against students on the basis of a disability, at what point does sort of an unsatisfactory outcome for that dispute resolution process between a student or between the SU and the independent school over a particular student placement, at what point does that sort of rise to the level of that school potentially not being eligible to receive public dollars? Like, what does the process look like at that point? If that makes sense.
I always like to give the chair a chance and defer to her. The dispute resolution process is geared toward getting the student in the school of their choice with the services that are required. It's not geared toward consequences against the school and its approval process. That would be a separate process that would be most appropriate in a complaint that a policy or action or inaction of the school has violated some aspect of the law or the rules. And the facts might be exactly the same, but it would be important to run the process so that the state board, if they did find a violation, could take that action against approval status. We also have to remember that the Vermont Human Rights Commission has jurisdiction over the Public Accommodations Act. So there likely would be a jumping off point where a person would have a right to make a complaint to the Human Rights Commission. That process would run its course. And again, the state board would treat the outcome of that process as factual evidence it would consider in a hearing about approval status.
I'm sorry,
go ahead.
It's Rule 2229.4, which I'm going to see if I can find it online and share it. So you can keep talking, but I'll see if I can find that because that might answer the question.
We'll jump to another question in the meantime. Representative Stone has a question.
Okay, sorry. I'm trying to tie everything together. So currently I have up Doug Hoffer's audit from 2020. And I just want to go back to what you said, Emily, about the scenario you gave, that it would really be up to the school's policy, like with the ski school example. But isn't it true that the policies don't have to be overseen by the state, the policies that those independent schools are putting in place, right? Because their governance isn't overseen by the state. Is that correct? Just looking at like the audit, looks like that was one of the differences.
Right. I'm going to take a guess. I think you're looking at the part of the audit about the governance board not being publicly elected and not warning meetings, right? It's not a school board, it's a private governance board, right? That doesn't mean that the state can't enforce its minimum requirements for policies that an independent school's got to adopt, right? So an easier example, more straightforward example might be the policy on non-discriminatory school branding. The state has put right there in the law, you've got to have one, it's got to meet these minimum requirements for content and outcomes under that policy. That's just the fact that independent schools got to adopt it in order to keep their approval.
Would currently our approved independent schools receiving public dollars required to adopt AOE required policies that public schools are?
Some,
Okay,
To some.
not all.
not all. There's definitely places in the statutes where, depending on the policy goals of the General Assembly, that's been a requirement just to public schools, or that requirement has been extended in some cases to approved independent schools, and in some cases has been extended to all independent schools. It depends on the topic.
Let me just pull one out, hazing, harassment, and bullying policies.
Okay, but you gotta give me time to flip.
Sorry, I thought you got it off the top of your head. Don't bother with it. We'll go to more questions. Representative Stone.
Is there going to be a report? Sorry, just looking at this, it's 3 years old, and with all these changes, I was wondering if there, I don't know who would put it out, if it'd be Doug Hopper and whoever. Is there going to be another one of these that's put out just like to kind of compare and contrast the stuff that you're talking so that it's more publicly accessible and easier to locate and read?
I think that the auditor's office is an independent office, publicly elected, and sort of follows their own.
But we could ask for it.
Yeah.
As people who elect these officials, right? Okay, great.
Representative Buss.
So in the instance when a person goes to an independent school and they need something specific on their IEP and the independent school cannot provide it, they have to go back to the school system and bring that person in. I'm correct so far that this can happen, correct?
Sure.
Now, then does the funding for that extra person get bifurcated so that the public school gets a little bit of the funding since it's providing a little bit of the instruction?
All the funding for that student comes from their school district.
So they can't retain anything for the portion of the burden that they retain by providing the instruction?
No school district should be paying for services it didn't receive, right? So if the school districts or the supervisory union in this case, if the supervisory union's staff delivered a service, no other entity, including the independent school, should be paid for that particular service. That would be double billing the state.
So Kirkland, you think of it this way, a student on an IEP, if they went to, Bob's public high school or Bob's private school, would pay that base tuition that every student pays, and then any additional services that were needed would be paid through the school, through the supervisory union, but for no more than the services that the student is getting. So in other words, no matter who's providing that service within the classroom, whether it's the supervisory union or the private school is going to bill for it, or the public school is going to pay for it. Either way, the money comes through the supervisory union, no more, no less than for the services being offered.
And it's occurring to me, I didn't present this information. A student's tuition is paid by the school district. The school district also, status quo and under our new rules, pays the excess costs of services for that student. And so when we talk about a $17,000 roughly tuition to an approved independent school, the special education services the student receives at the school cost over and above that tuition amount.
All right.
So
Jeffrey, do you have some more, please?
Well, back on the hazing, harassment, and bullying, I'm remembering that we had an independent school that came before the State Board of Ed not that long ago. And we denied the application for approval in part because the school did not have a posted policy on its website with regard to hazing, harassment, and bullying.
Not to dive too specifically here, I'm going to talk about 504 for a second. We had a speaker come speak to after hours here to an audience, said that a private school that does not receive any federal dollars is also exempt from having to accept a 504 student. Is that true? Or can we just assume that if it's an approved independent school that gets public dollars, that counts as federal dollars as well.
For the Agency of Education, it's more the latter, that these are our public dollars. Section 504 is a non-discrimination provision, right? It's a basic accommodation for disability. So we do all the time give technical assistance to approved independent schools on offering those 504 services to students. And it's our guidance that independent schools are responsible for providing those 504 services.
That they are required.
And it's also in 2229.1A that a student shall not be denied acceptance for enrollment if the reason would be that the student was protected under Section 504. So that's in our rules.
Okay, all right. So, yeah, I understand. And I guess, Jennifer, I guess I would ask you if you see anything particular that you'd like to see in statute, that the state board would like to see in statute to sort of belt and suspenders or provide a more statutory foundation for these rules.
That's a really good question. I think one of the things, again, we left reference to both the Public Accommodations Act and the Fair Employment and Discrimination, wait, I said that wrong. The Fair Employment Practices Act. We cited those by name and by statutory cite. We did not actually cite the language of the text in the idea that that language might change. So I think, and that issue was certainly beyond, the purview of the State Board of Ed. So we're constrained by legislative intent as expressed in statute or, acts. But should the legislature change that language to make it more prescriptive, that is something that I will sort of direct back to you and say, I think that probably could be made tighter, and we would welcome that change if that were something that were able to be accomplished.
So you're talking about actually changing the Fair Employment Practices Act, or?
I mean, yeah, that's a public policy issue that obviously extends far beyond schools. So that might be a conversation for another day, but okay. I am aware that, we took our anti-discrimination language as far as we could with the laws as it was currently written.
Great, thank you. Thank you. Committee, further questions? All right, we are all legal scholars now. Thank you both very much. Let me just check something out here. Okay. Great. Anything else from either of you that you just want to clarify or make sure we understand before we let you go?
I did look up the hazing, harassment, and bullying requirements. That's interestingly a policy required of all Vermont educational institutions.
Okay, so even recognized schools.
That's right.
Yeah, okay. All right. Well, great. Thank you both very much. Appreciate your time as always.
Thank you.
All right. I guess with that, we do not have testimony scheduled until 2:30. So we'll